Marlene Voss thought the courtroom belonged to her. The HOA president had forged liens, erased notices, and scheduled a secret hearing to take Grant Holloway's house before he could object. Her attorney even rehearsed the moment she would receive the deed. But when the doors opened, Grant did not enter as a frightened homeowner. He stepped inside wearing the county judge's black robe, and every whisper in the room died. Grant could not rule on his own case, but he did not need to. Hidden inside Marlene's evidence was a mistake so serious that one honest judge could unravel her entire empire before lunch. Stay with this story because Marlene's forged victory collapses the moment a missing signature reaches the open record of the court. Grant Holloway lived at Ashford House, a stone residence more than 100 years old, set on nearly 4 acres of land that had existed long before the gates of Blackridge Estates were ever built. The property predated the Homeowners Association entirely, and it did not fall under its authority. Grant held the original deed, the county-approved subdivision, records a formal exemption from the Homeowners Association, a certified plat map confirming his independent boundary lines, and a recorded right-of-way onto the public road. Every document a person could need to prove ownership free and clear sat inside a fireproof box in his study untouched for years because no one had ever needed to question it before. Marlene Voss had just been re-elected president of the Homeowners Association, and she carried with her a vision for what Blackridge Estates could become. She wanted a private clubhouse for the wealthiest residents, complete with a banquet hall, tennis courts, and a dedicated events pavilion. Ashford House sat on the single best parcel of land for the project. If she could seize Grant's property, she could link 2 sections of association land together and drive up the value of the entire development. The idea took hold of her the way an obsession does, quietly at first, then completely. She began with requests that seemed small enough to ignore. She demanded Grant repaint his front door. She insisted he tear down his stone fence. She banned guest vehicles from parking near his home. She fined him for refusing to display an association-approved house number, and then she billed him for maintenance on a private road he never used. Grant answered every letter the same way, calmly, with documentation attached, proving his home fell outside her jurisdiction. Marlene never cared about the truth of any of it. What enraged her was not the old house at all. It was the fact that Grant refused to acknowledge her authority. During one association meeting, Marlene stood before the full board and declared that every home inside Blackridge answered to Blackridge without exception. Grant, seated near the back, replied evenly that her authority stopped exactly where the county's recorded boundary line said it stopped. The room went quiet, and Marlene felt the sting of being corrected in front of people she governed. From that day forward, the fines stopped being fines and became something closer to threats. One morning, Grant opened an envelope and found a notice claiming he owed the association $38,600 in unpaid membership fees accumulated over 8 years. Grant knew immediately the document was false because he had never signed anything joining the association in the first place. He wrote back demanding the original agreement, and Blaine Rutledge, the association's attorney, sent him a blurred photocopy bearing a signature that resembled his name but was written in a hand that was clearly not his own. Grant understood then that Marlene was no longer trying to pressure him into compliance. She was building a paper trail designed to take his home through the court system itself, and she intended to do it quietly before he ever had the chance to fight back in the open. That same week, Grant noticed something strange. The forged agreement claimed he had signed it on a date when official travel records placed him in another state entirely working a case that had nothing to do with Blackridge. He said nothing about it to anyone. Instead, he wanted to see exactly how far Marlene was willing to go before he revealed what he already knew, and that patience would prove to be the sharpest weapon he carried into the fight ahead. Marlene and Blaine did not file an ordinary lawsuit. They pursued a quiet title action asking the court to formally recognize the association's fabricated debt as legitimate and binding. Their plan unfolded in 3 deliberate steps. First, they created falsified records, claiming Grant had been a paying member of the association for years. Second, they swore that proper notice had been delivered, and that Grant had simply chosen not to respond. Third, they intended to secure a default judgment, allowing the association to sell his home outright to recover the invented debt, all without Grant ever standing before a judge to contest it. Blaine hired a process server and instructed him to sign a sworn statement claiming the paperwork had been handed directly to Grant. In reality, Grant received nothing. One copy of the notice was dropped at an abandoned house on the far side of the county. Another was left in a mailbox that did not belong to him at all. The court record meanwhile stated plainly that Grant had refused service. Marlene believed he was simply a quiet man without family nearby and without the resources to mount a long legal fight, and in believing that she made the single greatest miscalculation of her life. What Marlene did not know was that Grant was in the final stages of being confirmed as a county judge. He had spent years as a trial attorney before serving as a special prosecutor, focused on property fraud, and his appointment had not yet been publicly announced because his formal swearing-in ceremony had not taken place. Grant told no one at the association about his new position, not out of secrecy for its own sake, but because he refused to use a title to intimidate anyone, and because announcing it too soon might give Marlene time to destroy the evidence she had already created. Nora Whitfield, the county's land records clerk, called Grant after noticing an unusual request to transfer ownership sitting in the system. The association had already prepared a deed transfer waiting only for a judge's signature to make it final. Nora warned him that a hearing had been quietly scheduled for the following Monday morning, only 4 days away. Grant went to the courthouse himself to examine the filing, and what he found there confirmed every suspicion he had been carrying since the fake debt notice first arrived at his door. The signature on the delivery receipt had been forged. The address listed for service was wrong. The parcel number on the complaint had been altered. A page inside the original deed had been quietly swapped for an edited copy, and the association was now claiming Grant's home had joined its ranks before the association itself had even been legally formed. That final detail alone was nearly enough to collapse the entire case. But something even more dangerous stood out to Grant. Marlene had asked the court to allow the association to take physical possession of the house on the very same day the judgment was issued. If Grant failed to appear, Marlene could change the locks, bring in private security, and declare the property hers before he ever had a chance to object in person. Grant filed his opposition immediately, but he made sure Marlene never learned that he had uncovered her plan. He asked Nora to preserve the original versions of every document filed in the case untouched and unedited. He also notified the presiding judge that he held a personal stake in a pending matter and formally withdrew from any judicial role that could touch the case in any way. The chief judge assigned Evelyn Prescott, a traveling judge from a neighboring county, to take over the hearing. Marlene was not told the name of the replacement judge until the very morning the hearing was scheduled to begin. That Sunday night, Marlene hosted a small celebration inside the association clubhouse, raising a glass and announcing to the room that by the next day Ashford House would finally belong to them. Across town, Grant hung his black judicial robe outside his closet door and prepared for an entrance that no one inside that clubhouse could possibly have imagined. On Monday morning, Marlene arrived at the courthouse with Blaine and 4 members of the association board trailing behind her. She wore a crisp white suit and carried a folder labeled Ashford Acquisition Final, as though she were arriving for a closing ceremony rather than a contested hearing. Outside, 2 association trucks sat waiting, loaded with new locks, signs reading property of Blackridge Estates equipment for removing security cameras, bolt cutters for the front gate, storage bins for Grant's personal belongings, and a signed contract for the demolition of an outbuilding on his land. Marlene had even invited a real estate developer to witness the moment, promising him possession of the property within 30 days. When a local reporter asked about the lawsuit, she described Grant as a homeowner who had simply refused to pay his dues, insisting the association was only protecting the interests of its residents. Blaine quietly warned her against saying too much before a ruling was even issued. But Marlene only laughed and told him that Grant did not even know the hearing was happening at all. Inside the courtroom, Blaine arranged his evidence in a precise, deliberate order meant to look airtight to anyone glancing at it. A falsified membership agreement, a list of accumulated fees, a signed delivery receipt, a fabricated warning letter, board meeting minutes approving the seizure, and a draft order transferring ownership sat stacked and ready. He planned to speak for no more than 10 minutes before requesting a default judgment outright. Marlene sat at the plaintiff's table checking the clock again and again, and when the clerk announced the case was about to begin, Grant had still not appeared. Marlene leaned toward Blaine and whispered that she had known all along he wouldn't have the nerve to walk in. Moments later, the side door of the courtroom opened. Sheriff Dalton Reeve entered first and asked everyone to rise. Marlene smiled, assuming the judge had arrived to hand her the keys to a house that was never hers to take. Then Grant Holloway walked through the door, not in work clothes or denim as Marlene had always seen him, but in a white dress shirt, a dark tie, and the black robe of a county judge. The entire courtroom fell silent. A board member dropped a cell phone. Blaine rose halfway out of his seat. Marlene looked from Grant to the bench and back again, unable to make sense of what she was seeing. Sheriff Reeve announced the arrival of Judge Grant Holloway, newly sworn in to serve the county court, explaining that Grant had simply come to complete a brief administrative introduction that had been scheduled weeks in advance and had nothing to do with the case itself. Grant did not take the bench for his own hearing. He stood before the room only long enough to complete the formal introduction, then removed the robe, folded it carefully, and placed it on the table beside him before walking to the defendant's side of the courtroom. He stated plainly for the record that he appeared that day as the owner of Ashford House, and not as a judge of any kind, and that he had already withdrawn from every judicial authority connected to the matter at hand. The side door opened again, and Judge Evelyn Prescott entered and took her seat at the bench. Marlene realized then that the true shock of the morning was not that Grant held a judicial title. It was that the man she had tried to deceive had spent much of his career investigating precisely the kind of fraud she was now attempting to commit against him. Before either side could speak further, Judge Prescott looked over the stack of documents Blaine had submitted and asked a single question that emptied the color from Marlene's face. She wanted to know why 3 separate filings from the plaintiff shared the exact same notary seal number, despite bearing 3 different dates. Marlene turned to Blaine for an answer, and for the first time all morning, her attorney had none to give. Judge Prescott allowed Blaine to speak first. He composed himself and told the court the case was simple. Grant had voluntarily joined the association. He had failed to pay dues for 8 years. The association had warned him repeatedly. The debt now stood above $38,600, and selling the home was, in his words, a last resort. He displayed the supposed membership agreement on the screen, and Grant let the entire document enter the official record without objection, choosing instead to wait for the moment it would matter most. When it was his turn, Grant rose and asked Blaine a simple question: when was the Blackridge Estates Homeowners Association legally formed? Blaine answered that it was formed on June 14, 2013. Grant then asked the court to enlarge the date printed on the agreement Grant had supposedly signed. That date read February 3, 2012. A murmur rolled through the room. Grant said plainly that according to their own paperwork, he had somehow joined an organization that would not exist for another 16 months. Blaine dismissed it as a clerical error. Grant pressed further, asking to see the notary seal attached to the signature. The name listed was Lydia Barnes. Nora Whitfield had already pulled the county's licensing records, which showed Lydia Barnes had not been certified as a notary until 2015, 3 years after the date on the contract she supposedly notarized. Blaine again called it an administrative mistake. But the pattern of mistakes was beginning to look like something else entirely. Grant introduced a third piece of evidence. On the date the agreement claimed he signed it, he was participating in a federal trial more than 1,000 miles away. Timesheets, a plane ticket, and official court records all confirmed he could not have been anywhere near Blackridge Estates that day. Judge Prescott asked Marlene directly who had supplied the contract in the first place. Marlene claimed she had simply found it in the association's storage archive. Grant asked to see the original. Blaine admitted he had only ever possessed a photocopy, and Nora confirmed the association had never produced an original despite repeated requests. Grant moved next to the alleged debt itself. The association claimed fees dating back to 2016, yet Ashford House had been formally exempt from every association obligation since a subdivision filing recorded in 2009. The map the association had submitted to the court had shifted the property boundary nearly 200 feet in order to wrap Grant's land inside their jurisdiction. Grant placed the original county map beside the association's altered version, and a natural creek appeared in 2 entirely different locations on each one. A detail no honest surveyor could explain away. Judge Prescott began questioning Blaine directly about his obligation to verify documents before submitting them to a court of law. Blaine insisted he had simply trusted the information Marlene provided him. Marlene, in turn, tried to blame a former office employee who had since left the association. Grant did not argue the point. He simply asked the court to note that Marlene had just admitted the fabricated paperwork came straight out of her own office. Then Grant introduced the very first delinquency notice. The document claimed it had been mailed to him on April 8th. The postmark on the actual envelope read May 19th, proving the notice had been created after the association swore it had already been delivered. Judge Prescott denied the request for a default judgment on the spot. Marlene assumed this was only a minor setback. What she did not yet understand was that Grant had no intention of asking the court to dismiss the case quickly. He wanted every forged document exposed publicly, one at a time, before revealing the evidence that would end everything. Grant told the court there remained one more document they had not yet examined, the sworn statement claiming he had personally been handed the legal notice at his front door. As he said it, the man responsible for delivering that notice, seated quietly at the back of the courtroom, rose as if to leave. Sheriff Reeves stepped forward and locked the courtroom doors before he could reach them. The process server, a man named Derek Madsen, was called to testify. His sworn statement claimed he had handed the notice directly to Grant at 7:42 in the evening at the front door of Ashford House. He described the man who answered as roughly 50 years old with graying hair wearing a brown jacket who refused to sign and threw the papers to the ground. Blaine used this description to insist Derek had absolutely encountered Grant that night. Grant asked Derek if he was certain about the date and the time, and Derek answered that he was. Grant then played security footage from his own front entrance. The recording showed no one had approached the door at any point during that window of time. Marlene objected, suggesting the footage could easily have been altered. Grant introduced verification records from the cloud storage provider itself. and forensic document examiner Audrey Langford confirmed the timestamps had never been tampered with in any way. Grant followed with records from a county animal rescue fundraiser he had attended in person that same evening, more than 40 miles from his home, backed by photographs, a receipt, and a printed guest list. Under pressure, Derek began to soften his story, suggesting he might have delivered the papers to someone who merely resembled Grant. Grant asked him to point to the correct house on a county map. Derek pointed to the wrong address entirely, an abandoned property nearly 6 miles from Ashford House. Grant then introduced location data pulled from Derek's own work application, which showed he had never set foot near Ashford House on the date listed in his sworn statement at all. Judge Prescott warned Derek that lying under oath was a criminal offense. Derek looked at Blaine, then at Marlene, and finally admitted that an association employee had handed him a statement already filled out, asking only for his signature in exchange for $1,500. Judge Prescott asked who had approved that payment. Derek answered simply that it was Marlene Voss. Marlene stood and denied it outright. But Grant asked Nora to pull the association's own financial filings submitted alongside the lawsuit. Buried inside a legal expense ledger was a payment of $1,500 made to Derek's company, signed and approved by Marlene herself, with a note attached that read "Expedited Service Ashford." Marlene insisted the payment was entirely legitimate. Derek pushed back, telling the court Marlene had called him personally to instruct him never to actually approach Grant's home because Grant, in her words, might cause trouble. Sheriff Reeve asked Derek to hand over his phone, and the text messages between his number and Marlene's were still there, instructing him not to knock on the Holloway door, to simply sign the papers and to let Blaine handle everything else. Blaine claimed he had no knowledge of the message at all. Grant chose not to accuse him directly in that moment, instead asking the court to seal the phone and the full case file for the purposes of a criminal investigation. Judge Prescott rejected every claim that Grant had willfully avoided the hearing and ruled that the association appeared to have deliberately stripped him of both proper notice and a fair chance to defend himself. Just as the room believed the matter might finally be settled, Grant spoke again, telling the court that hiding the hearing from him had only ever been the method and that it was time to discuss the true purpose behind it. He placed a set of clubhouse blueprints on the table showing that Ashford House had already been marked for demolition 6 months earlier. Grant called real estate developer Preston Hale to the stand. Preston admitted his company had signed a memorandum of understanding with the association regarding a project called the Black Ridge Heritage Club. Under that agreement, the association would hand over control of Ashford House. The home would be demolished. The land would become the main entrance of the new clubhouse. Preston's company would pay the association $2,400,000. Marlene would personally receive a consulting fee of $180,000, and construction had to begin within 30 days of the association taking possession of the property. Judge Prescott asked Preston why he had signed a contract for property the association did not yet legally own. Preston explained that Marlene had assured him the lawsuit was purely a formality and that Grant would never even appear to contest it. Grant produced email correspondence between Marlene and Preston that confirmed exactly that. In one message, Marlene wrote that the court would award them the house by Monday and instructed Preston to have a demolition crew ready within the week. In another, she wrote plainly that the old exemption would not matter at all once they secured a default judgment proof that this was never a misunderstanding but a calculated plan carried out with full knowledge that Grant's home had never legally belonged to the association at all. Before moving to the financial evidence, Grant reminded the court that none of the forged paperwork had appeared by accident. Each document had been built with intention, layered carefully enough to survive a passing glance but never a genuine inspection. He explained that fraud of this kind rarely announces itself through a single dramatic lie. It hides inside small inconsistencies, a wrong date here, a mismatched seal there, until the pattern becomes impossible to ignore. Judge Prescott agreed, noting that the volume of errors alone suggested deliberate construction rather than careless mistake, and she asked Grant to continue. Grant went further, showing that Marlene had used $96,000 from the community's maintenance fund to help finance both the lawsuit and her private development deal. The withdrawals were buried under vague labels such as landscaping upgrades, planning consultation, safety inspections, emergency legal services, and resident amenity development. Miles Garrison, the association's former treasurer, appeared before the court and explained that he had objected to using association funds to pursue Grant's home, and that Marlene had removed him from the board shortly afterward, accusing him of financial mismanagement to justify Tudu. Miles had kept a personal copy of the accounting records because he feared Marlene would alter the official version. His ledger showed that Marlene had funneled association money into her own consulting company, that Blaine stood to receive a bonus if the association successfully claimed Ashford House, that one board member had been promised a cut of future profits, that the fines levied against Grant had been backdated after the fact. and that the entire $38,600 debt had never once appeared in the books before the month the lawsuit was filed. Blaine challenged the authenticity of the copy, but Miles produced an email in which Blaine had personally asked him to delete a note labeled Ashford Acquisition. Blaine's composure began to slip, and he insisted every action he had taken was based solely on instructions from his client. Marlene turned toward her own attorney, sensing exactly what was coming, that Blaine was preparing to place the full weight of responsibility onto her alone. Grant did not raise his voice. He only asked Blaine one question: whether he had ever explained to Marlene that using forged documents to obtain a court judgment could constitute fraud upon the court itself. Blaine invoked attorney-client privilege and refused to answer. Judge Prescott ordered the entire file forwarded to the State Bar Association and to a special prosecutor's office. Marlene requested permission to withdraw the lawsuit entirely. Grant objected, explaining that withdrawing now could allow the association to avoid a formal ruling on fraud altogether. Judge Prescott agreed to continue the hearing in order to determine appropriate penalties. Before the session ended for the day, Grant opened a sealed envelope delivered by Audrey Langford. Inside was the forensic result of the signature analysis, and it confirmed that the name Grant Holloway on the association contract had never been written by Grant at all. It had been copied directly from an entirely different document that Marlene once had access to. Audrey Langford explained her methodology to the court in careful detail. The signature on the association contract had not been handwritten at all. It was a digital image lifted from an older document, then printed directly onto the forged agreement. She pointed to identical, unmistakable markers: a broken ink stroke on the letter G, a distinct slant on the letter H, a tiny fleck of dust beneath the final stroke, and spacing between the two names that matched down to the pixel. No two handwritten signatures could ever align that perfectly, she explained, because human handwriting simply does not repeat itself with mechanical precision. Grant asked which document the signature had originally come from. Audrey displayed a drainage repair request Grant had submitted to the association 3 years earlier, after association pipework had flooded part of the public road beside his property. Grant had signed that letter himself, and Marlene, in her role as association president, had received the original. The signature used on the forged contract had been cut directly from that very letter. Audrey further discovered that the forged agreement had been created using a document template that was not released until 2021, despite the contract itself bearing a 2012 date. The font used had not even existed within the association's software at the time the agreement claimed to have been signed. The printer that produced the fraudulent document also left behind an identifying code. Sheriff Reeve had already obtained a warrant to examine the printers inside the association office after Derek admitted to his false statement, and the code on the forged contract matched a printer located inside Marlene's private office. Marlene argued that any employee could have used that machine. Sheriff Reeve then presented building access logs showing the document had been printed at 10:18 at night, at a time when only Marlene's keycard had been used to enter the building at all. Hallway camera footage showed her entering the office, carrying a stack of papers, and leaving 20 minutes later. Blaine insisted he had never seen the original forged document and began putting distance between himself and Marlene. Marlene in turn accused Blaine of designing the entire strategy himself. Judge Prescott warned both of them that the courtroom was not the place to trade uncontrolled accusations against one another. Grant asked to call Marlene as a witness. On Blaine's advice, she invoked her right against self-incrimination and refused to answer any questions. Her silence could not be used to establish criminal guilt, but the court was still free to weigh the independent evidence already before it in the civil matter. Grant presented one final piece of evidence regarding the forged signature, a copy of the fraudulent contract discovered on Marlene's own computer saved under the file name Holloway, signed final. The document's edit history showed an image titled grantsignature.png had been inserted directly into the file created under Marlene's personal account. Judge Prescott formally declared the association contract a forgery with no legal effect whatsoever, and ruled that every debt, lien, and demand connected to the property was void from the beginning. Residents who had gathered to watch the hearing began to grasp that their own community funds had bankrolled a criminal scheme, and several quietly rose from Marlene's side of the room and crossed to sit on the other. Judge Prescott asked Grant what remedy he wanted the court to impose. Grant did not ask for Marlene's home. He did not ask for control of the association. He asked only that his property be protected, that the residents' money be returned, and that every person who took part in the scheme be held individually accountable. It was exactly what Marlene feared most, because it meant she could not force the entire association to absorb the consequences that belonged to her alone. Judge Prescott recessed briefly to review the full record. In the hallway outside, Marlene tried to negotiate privately with Grant. She offered to erase every fine issue, a written apology cover, his legal costs, grant him veto power over future association projects, and resign from her position within 6 months. In exchange, she wanted Grant to keep the evidence quiet and drop any request for a criminal investigation. Grant refused. He told her the matter no longer concerned only his home. Marlene had spent money belonging to hundreds of residents, falsified public records, and attempted to turn a court of law into an instrument of theft. Marlene warned Grant that the scandal would drag down property values across the entire neighborhood. Grant answered that the value of any community could never be protected by hiding the crimes of the person running it. When the hearing resumed, Judge Prescott read her ruling aloud. Ashford House had never belonged to the association. Every fee and fine levied against Grant was void. The lien against the property was dissolved immediately. The association was barred from filing any further claim against the home without express court approval. Grant would be reimbursed for the full cost of his legal defense. Marlene and those directly involved would bear personal financial responsibility for the resulting damages. The association was ordered to repay the $96,000 diverted from the community fund. An independent auditor would be appointed to oversee the association's finances going forward. Every document in the case would be forwarded to the county prosecutor, the State Fraud Investigation Unit, and the Bar Association. Blaine's ability to appear before the court was suspended until disciplinary proceedings concluded. Judge Prescott also imposed civil penalties against Marlene for committing fraud upon the court, bringing the combined financial obligation of Marlene Blaine and their co-conspirators to $412,000 before any criminal penalties or individual resident lawsuits were even factored in. Marlene reacted furiously, vowing the association would appeal. Judge Prescott told her she was entitled to that right, but that every disputed asset would remain frozen and every association account would remain under supervision throughout the process. Sheriff Reeve approached the plaintiff's table. He did not arrest Marlene immediately since the criminal investigation was still underway, but he handed her a formal order to preserve all evidence and a notice prohibiting the destruction of any records. As Marlene left the courtroom, the trucks that had been waiting outside to seize Grant's home were still parked at the curb, and Sheriff Reeve ordered them searched. Inside one truck, deputies found a full inventory of items from inside Ashford House, including furniture, artwork, personal documents, and a private safe proof the association had planned to take property that was never even attached to the land itself. This was no longer simply a property dispute. It carried the markings of an organized theft. Marlene watched Grant descend the courthouse steps. Unable to shake the fact that she had arrived that morning expecting to walk away with the keys to his home, only to lose the keys to her own association office by early afternoon seized under the very preservation order she had just been handed. News of the hearing spread quickly through Black Ridge Estates. Residents demanded an emergency meeting, and for the first time in years, Marlene was not permitted to lead it. The independent auditor uncovered a long trail of misconduct, including personal expenses paid directly from association funds, uncompeted contracts awarded to companies with personal ties to Marlene, dozens of fines created without any valid board vote homeowners, threatened with fraudulent liens, a reserve fund missing nearly $270,000 financial reports sent to residents that had been quietly altered, and money earmarked for road repairs diverted straight into the clubhouse project. Miles Garrison was publicly cleared before the community. 3 board members resigned and agreed to cooperate with investigators. One admitted that Marlene routinely had the board sign blank meeting minutes, filling in the contents herself afterward. Another turned over a recording of a closed-door meeting in which Marlene could be heard saying that once a court order existed, no one would ever question how it was obtained. Blaine attempted to negotiate with the prosecutor, handing over emails and documents to demonstrate that Marlene had directed the entire scheme. Yet those same emails also proved Blaine had known the filings were compromised and had submitted them to the court anyway. His license to practice law was suspended pending a full investigation. Marlene was formally charged on multiple counts, including document forgery, perjury, obstruction of judicial proceedings, conspiracy to seize property, misuse of community funds, and inducing a witness to submit a false sworn statement. Grant did not take part in the prosecution itself, since his position and his personal stake in the case could create a conflict, and he forwarded every document to a special prosecutor from an outside county to preserve the integrity of the process. That distinction mattered more than anyone in Black Ridge Estates fully realized at first. Marlene had used power to serve herself. Grant had voluntarily stepped away from power the moment the law required it, even when keeping it might have benefited him personally. At the community meeting, residents voted to remove the remaining board members entirely. A temporary leadership committee was formed under 3 simple principles. No fine could be imposed without a proper appeal process. No major expenditure could occur without a resident vote, and no homeowner could ever again be threatened with the loss of their home over an administrative dispute. Residents asked Grant to serve as interim association president. He declined, explaining that Ashford House had never belonged to the association, and that he had no desire to govern the community that had tried to take it from him. Instead, he helped them find an independent attorney to rewrite the association's governing rules from the ground up. The clubhouse project was cancelled entirely. Preston Hale withdrew from the agreement and returned his deposit once he understood the land had never legally belonged to the association in the first place. Ashford House was protected under a permanent order confirming Grant's title, ensuring that any future filing contradicting the ruling would automatically be flagged for review. A month later, Marlene returned to Ashford House one final time, asking Grant to write a letter requesting leniency on her behalf. Grant looked at the woman who had once planned to throw him out of his own home and told her plainly that he would not seek revenge against her. But he also would not lie to spare her from the consequences of the truth. 6 months later, Marlene's criminal case ended in a negotiated plea. She agreed to give up every position she held within the association to repay the community in full, to sell personal investments to cover the resulting damages, to be barred from serving in any financial or association leadership role for a number of years, to serve a term of incarceration and padding, supervised release determined by the court, and to cooperate fully with the ongoing investigation into everyone who had assisted her. Blaine lost his license to practice law entirely after a disciplinary board concluded he had knowingly submitted documents he believed to be fraudulent. Derek received a lighter outcome in exchange for his full cooperation and honesty, though he still faced consequences for his false sworn statement. Residents recovered the funds that had been misused, and the newly formed board decided the land once intended for the private clubhouse would instead become a community garden and an open gathering space without touching a single inch of Grant's property. Ashford House remained standing exactly as it always had. Grant repaired the stone fence that association workers had once damaged, and he kept the very same front door color that Marlene had once demanded he change. A small sign was placed just inside the gate reading Ashford House Private Property Established 1908. There was no threat carved into that sign and no mention of Grant's title. Only the simple recorded truth of ownership. On the day Grant presided over his first official hearing as a sitting judge, he put on the same black robe once more. Before stepping into the courtroom, Sheriff Reeve asked whether he had ever worried that wearing that robe on the day he faced the association might make people believe he had used his position to win his own case. Grant said he had considered that very question carefully, long before that morning ever arrived. He explained that he had not worn the robe to intimidate Marlene. He wore it because the introduction ceremony had already been scheduled, and because he wanted everyone in that courtroom to witness a clear, unmistakable line between the man and the office he held. After the brief introduction, he had removed the robe, taken his place as the defendant, and allowed an independent judge to weigh the evidence without his influence anywhere near the bench. The robe never saved his home. The truth saved it. The public record saved it. The people who preserved the evidence saved it, and a system that functioned exactly as it was designed to function stopped Marlene from turning a lie into a legal claim of ownership. That evening, Grant returned to Ashford House as the sun began to fall behind the tree line. He laid the black robe over the back of a chair in his study right beside the original deed to the home his family had held for generations. Outside workers quietly removed the last association sign the group had planted near the edge of his land. Marlene had believed power meant the ability to force other people into obedience. Grant understood that real power was the willingness to obey the very limits placed upon oneself, even when breaking them might have brought a personal advantage. He closed the case file, set it beside the deed, and looked out toward the stone fence in the fading light. For years, that fence had been treated as an inconvenience, something for Marlene to fine mock and threaten to tear down. Now it stood exactly where it always had, holding the same quiet line it was built to hold, long before anyone imagined a homeowners association could claim ownership over land it never touched. Ashford House had never needed a judge to claim it as his own. It only needed one person willing to walk into a courtroom and force every liar inside it to answer fully and truthfully to the public record. Marlene had taken him to court believing a forged signature could steal his home from him. He had walked in wearing the county judge's black robe, but in the end it was not the title that took everything from her. It was the truth laid bare in open court that no forged document could ever survive.